Good afternoon, everyone. It's my pleasure to welcome you all to the 5th Annual DV Educational Conference. Before we begin, I just wanted to remind you, if you're seeking CLE credits, make sure you not only sign in, but that you sign out at the end of this conference so that we can ensure that we get you the credits. What I'd like to do is to introduce each one of the speakers and tell you a little bit about them. They're all in your program agenda, so I'd like to start with that. I'd like to first introduce my colleague on my left, Professor Deborah Stark. She joined the John Marshall Law School faculty in 1994, which means she has been my colleague and friend for more than 20 years, and her office is right next to mine on the hallway in the CBA building. Before she joined our faculty, she was in private practice for 8 years with the law firm Catt & Muchin. She is the founder of our domestic violence clinical advocacy program at John Marshall. We're very, very proud of this program because it fits so well with the law school mission. And she's done an amazing job of creating all these different practice areas and affording victims of domestic violence with opportunities to get the help that they need to ensure, or at least to try to ensure, their safety, because there are so many ways in which they struggle as victims. A key initiative of the Domestic Violence Clinical Advocacy Program, which Professor Stark initiated, is the Safety Through Knowledge Legal Assistance Project, where specially trained students working under the supervision of highly talented adjunct faculty, some of whom are here, supervising attorneys and volunteer attorneys provide legal information, advice, and other forms of legal assistance in 10 different areas of law. So we're really, really proud of Professor Stark. Our next speaker is Kathleen Doherty. She has been the executive director of the Chicago Metropolitan Battered Women's Network since July 1st, 2014. Prior to this, she served as the executive director of Between Friends, a domestic violence provider in Chicago, winning the prestigious 2013 Alfred Axelson Award for Nonprofit Managerial Excellence. She has 30 years of professional experience and volunteer experience in health, youth development, and gender-based violence. Our next speaker, Christine Hunt, graduated from the John Marshall Law School, where she received both her JD degree and a certificate in trial advocacy. She has a bachelor's degree in crime law and justice with a minor in psychology from the Pennsylvania State University, and she's the principal attorney of Christine M. Hunt, PC, which focuses primarily on family law, including divorce, parentage, parenting time, parental allocation, child support, and post-degree matters. Carlos Montoya our next speaker is a supervising attorney with the John Marshall Law School's Family Law and Domestic Violence Clinic, where he instructs and advises in the areas of employment protections and crime victim compensation for domestic violence victims. He's also currently employed as a vice president in the legal department of J.P. Morgan Chase & Company, where he handles employment discrimination and financial industry regulatory matters. Kelly Walters is our next speaker. She graduated from DePaul University with a bachelor's degree in 2001. She then spent 2 years working as a domestic violence counselor in an emergency shelter before enrolling at the John Marshall Law School, where she earned her JD degree. During that time, she was an intern at the John Marshall Law School's Fair Housing Clinic, where she worked for 4 semesters. She's currently the owner and practicing attorney at Walters O'Brien Law Offices, specializing in civil rights and criminal defense. Gina, okay, I thought I had counted correctly. We're missing a speaker. Gina Spada will be joining us a little bit later. She's the principal attorney at the law office of Gina M. Spada, PC. Her practice helps clients solve problems in the following areas: trusts and estates, guardianships, and business services. Before I turn it over to our speakers, I would like just a little opportunity to talk to you about our domestic violence clinic and advocacy program. As I said before, we're really proud of the work that Deborah Stark has done, not only to found and create this program, but to grow it into so many important practice areas. Our award-winning clinic operates like a mini law firm and think tank representing domestic violence survivors and exercising their rights in 10 areas of law. And I just want to mention those quickly. Orders of protection, divorce, parentage, and child protection cases, debt relief and credit repair, immigration relief, federal and state income tax relief, estate and financial planning, housing protections, employment protections, crime victim compensation, and self-defense criminal cases. It makes me tired just mentioning all of those areas. I'm just in awe. It also advocates on behalf of DV survivors through our development of empirical and comparative law-based law reforms and the creation of innovative resources for those unable to afford and obtain legal assistance so they can learn about, which is education is so important. They can learn about, navigate, and benefit from the many legal protections here in Illinois and under federal law. And we also train the next generation of attorneys on the counterintuitive aspects of domestic violence, the special legal protections available for domestic violence survivors, and how to employ a trauma-informed and empowerment model of representation after the students graduate. Before I turn this over to the speakers, one last thing I want to say. I want to thank all the speakers, first of all, for planning and participating in the conference. It takes a lot of time out of the great work that you already do. I want to thank the John Marshall staff and the events management team for their efforts in putting this together. And I want to thank all of you in attendance and those who may be viewing the recording for your interest in this really, really important topic. So thank you very much.
That was Julie Spanbauer, Vice Dean of the Law School and a longtime friend. And I can honestly say that I can't think of anybody more dedicated to the law school and who works harder than she does. And I know she needs to leave, so you can go if you need to. And I echo her comments. Thank you all for attending, and especially thank you to the individuals sitting up here with me, many of whom work in our clinic, and there are other individuals who work in our clinic, but it would turn into a 10-hour seminar instead of a 3-hour if everybody presented in all the areas. But they're an amazing group of dedicated individuals who make a real difference in the lives of others, not just in helping the DV survivors, but also training the next generation of students. So thank you. I can't thank the group enough. Okay, so there are 4 goals that I have for this conference. The first goal is for you to see how your practice areas might in fact connect up with domestic violence. This is probably the biggest purpose of this conference, is for you to see this connection. I will explain for the second goal, where it talks about the connection between DV competence and legal competence. I'll be explaining in future PowerPoints what do I mean by DV competence. And legal competence is referring to the standard all lawyers must meet under Rule 1.1 of the Illinois Code of Professional Responsibility. And in terms of screening, having you learn how to screen for DV and counsel-related protections, people always say it's better to show than to tell. There'll be a little bit of telling, but there'll be a lot of showing. We're going to be doing some simulations on that. The fourth goal I have may sound hyperbolic, but I don't think so. I think another goal I have is for you to empower you to help save lives. I think everybody sitting in this room is going to learn something that maybe they didn't know before that will actually could change somebody's life for the better and maybe even save their life. I'm Deborah Stark. I was already introduced. So let me begin it this way on the issue of screening. Have any of your clients been survivors of domestic violence? Show of hands. Okay. For those of you who, didn't raise your hand, how would you know if any of your clients are survivors of domestic violence? Have any of them told you they're a survivor of domestic violence? Now, if you run a clinic, a domestic violence clinic, like we do, of course, they all self-identify, but most DV survivors are not going to self-identify if they're, having an estate plan being done, or a debt issue, or a housing issue, etc. They may not self-identify. So let me ask those of you who aren't in a clinic already, Have you ever asked a client whether they were a survivor of domestic violence? Any show of hands, anybody who's not doing this day-to-day representing DV survivors, have you ever asked a client? And I'm not surprised that very few hands went up. It's not a comfortable thing to do. It seems like a very personal, private thing, and that's why we are kind of bringing it out and we're making this big claim that it's actually tied in with legal competence. What would cause you to think a client might be a survivor of domestic violence? That's more of a rhetorical question, but do think about it. What does a survivor of domestic violence look like? Did you imagine a woman with a black eye or a broken nose? Now, I suppose if somebody came in to see you looking like this, you might ask about it, right? They may have an excuse about a skiing accident or something, but it might tip you off a little bit, or your neighbor or whoever. But what if, instead, she comes into your office and she looks like this? Same person, right? Would you think she's a survivor of domestic violence? So statistically, it's highly likely that some of your clients are, in fact, survivors of domestic violence. Domestic violence has been labeled a public health epidemic, with 1 in 4 women and 1 in 7 men having experienced physical violence from an abusive intimate partner at some point in their lifetime. And this occurs in every group within society. So even individuals who went to Harvard and Morton School of Business are survivors of domestic violence. So groups of every socioeconomic status. But you may be still wondering, even if some of my clients are survivors of domestic violence, how does that impact how I represent them? So the answer, in my view, depends on your practice area. And I kind of created 3 tiers of practice areas. Tier 1 is situations where domestic violence in the foreground or background for your client is highly likely, and there are protective laws in place. This is where you have the strongest need to screen for domestic violence and be knowledgeable about it. In tier 2 areas of law, domestic violence is a significant possibility, and there are protective laws in place. So it's really relevant still, kind of like employment and housing protections, things like that. And then for everything else virtually, tier 3, if you're involved in a practice of law where your client is involved in an agreement, whether it's a transactional type agreement, a transfer of rights in property, or even settling a litigation matter, there is a possibility that coercion is going on that would taint your agreement. So I would argue that virtually every practice area within the law, there could be a domestic violence issue and the need to know the laws that might apply. So real quick, I just wanted to get a sense of your backgrounds. How many of you, and here you can show your hands, either work on family law, child protection, or criminal law cases? Okay. So that's the tier 1 group. That's where you're going to see it the most. How many of you work on immigration, international human rights, housing, employment, debt relief, income tax, elder law, or I shouldn't say even. We can all think of examples in entertainment law, but entertainment law. So that's tier 2, so 1 person. And how many of you work in business law, intellectual property law, real estate, estate planning, general practice? Thank you for coming, tier 3 person. Because a lot of people wouldn't see the connection, or tier 2 and tier 3. So I think the first thing that I wanted to spend some time on for everyone in here, and I apologize to those of you who are steeped in this and you know all this already, but for those who don't, domestic violence, the realities of domestic violence, a lot of it's very counterintuitive. And it's really important if you're going to be competently representing your client, no matter what their underlying goals are, their underlying concerns, you always have to know that. I used to learn when I was a real estate lawyer, you need to know the underlying business of your client. Here, you would need to know about domestic violence to really be able to represent somebody who has issues that are related to that. So the first thing that I want to talk about is the cycle of violence. Most people don't enter into a relationship and on day 1 they're assaulted and then they stay with the person. Obviously, if something bad like that happened on the first date, it would be over. And it kind of, sometimes when you talk to DV survivors, you'll hear that, wow, you know, my partner was so wonderful when we met. He was so attentive and loving and all these positive, warm things. So it's the opposite of, you know, what happens later. But over time, emotional abuse starts to happen, isolation from family and friends, criticism, and eventually there's an explosion and there's a violent attack. And then sometimes it's a pattern, doesn't happen for every relationship, but sometimes a person will say, oh my, I've never done that before, it'll never happen again. And then there'll be, sometimes people refer to it as a honeymoon period. I'm going to put real big quotes around that. But the idea is things calm down and maybe it goes back to the loving relationship it once was. But then cycle of violence starts up again. The emotional abuse starts, the survivor of the violence feels like they're walking on eggshells, not to say or do the wrong thing. They're kowtowing to the abusive partner, but nothing works completely and there's another explosion, and then this thing goes round and round. But what tends to happen also, and again, I'm just saying tends, it doesn't have to happen this way in every relationship, is that the eventually there's not, I'm sorry, it won't happen again. Instead, it's your fault. Or it could be, I don't know what you're talking about. This is not abuse. You're abusing me. So there's sometimes gaslighting going on. So why do I reference the cycle of violence? First of all, it's so important to know about this because if you're trying to get protections for your clients and it's based on their status as a DV survivor, you have to explain to a lot of people, why didn't she leave sooner? If you can't explain that, if they're not already educated on this, they're not going to believe your client. If all those things happened, why was she still with this person? I just don't believe it. So that's a problem. Explaining the delay that sometimes happens between when you actually come in to get the help and, you know, the last, what a court would recognize normally as a significant act of domestic violence is a problem too to have to overcome in different areas. So knowing about the cycle of violence can help explain why, you know, she's coming in now and she didn't come in earlier. And I already mentioned the issue about the client mollifying the abuser for all these years. So you may think, well, nothing's happened in 4 months. So where's the emergency? You know, where's the problem here? Maybe the person's no longer angry and everything's fine. So it's important to recognize the cycle of violence and how that fits in with some of these counterintuitive realities of domestic violence. A second, I'm going to jump to 3 and get back to number 2. Another important point is it's not just physical abuse. A lot of people just think of the physical abuse. It's emotional abuse and financial abuse. And I'll give some examples. So in terms of the non-physical abuse. So the physical abuse, you would imagine pushing, slapping, punching, and other forms of physical abuse. In terms of emotional abuse, which can be sometimes just as harmful, name-calling and demeaning treatment calculated to destroy the survivor's sense of self-worth, keeping the survivor up all night, causing the survivor to become isolated from family and friends, threats to harm or take away the children or pets if the survivor fails to comply with the abusive intimate partner's demands, throwing the survivor out of the house to cause her to become homeless, or causing a nuisance at the apartment she lives in, causing her to be evicted, threatening to report her to immigration if undocumented, or taking away her identity documents, and threatening to harm, kill not only her, but her family and children if she tries to leave. In terms of financial abuse, taking control over the money and putting the survivor on an inadequate allowance, charging up large debts on the survivor's credit without her or his consent, causing the survivor to lose their job by making them late to work due to the violence they are recovering from, or due to missed days at work, and or due to repeated calls to the survivor on the job that reduces their ability to get the job done. Stealing or destroying the survivor's phone, damaging their car, and injuring her in ways that lead to expensive hospital and doctor bills. Now, I was very careful which examples I'm giving because virtually all of these examples, the law, at least in Illinois, has responded in ways that are that address these sorts of problems. And I also want to emphasize that physical abuse includes sexual abuse as well, where somebody is coerced into performing a sexual act that they are not comfortable with and do not want to perform. At this point, the DV survivor is likely cut off from family and friends or too embarrassed to tell them, or they may fear for their family and friends' safety if they tell. So they're in a deep place. So why is it important to realize that there are multiple forms of abuse? First of all, it helps explain the large barriers to becoming safe and again, answering the question, why didn't she leave? Why didn't she just leave? And it emphasizes the need to address these barriers. And I'm proud to say that Illinois has among some of the best protections among the states on this, with a few exceptions that I'll share also my opinion on. Another key aspect, the second point here, is that domestic violence is often not an anger management problem or not a drinking problem, although there's co-occurrence with substance abuse. But a lot of the abuse is due to a desire to coercively control the intimate partner. Why is that important to know? Because when somebody leaves an abusive intimate partner, that's the most dangerous time when the abuse is due to a desire to control somebody. Because when they're leaving, they're taking away that control. And to regain the control, usually the abuse escalates. First, there might be promises to do better, etc., but then it's going to often lead to violent behavior. And we've all heard the horrific stories where somebody who threatened to kill their wife if she ever left, they make good on the threat. So separation assault is the phenomenon I'm referring to. It's very serious, and it affects how you represent your clients. We make it a practice in our clinic to always perform risk assessment and safety planning, have it done by one of our DV service organization collaborators, and I feel that that puts us in a better position to protect the client, not take steps without always thinking about their safety and how it would affect their safety. So in addition to knowing the nature and dynamics of domestic violence, and I'm sorry it was such a short description, another part of DV competence is knowing the key protective laws that help survivors of domestic violence, especially in your practice area. There are many, many such laws, and due to time constraints, I'm just going to say a few words about each, not go very in-depth, because there are so many laws to get through, and my talk's limited to 1 hour, and I'm going to stick to it as best I can. They're laughing because they know me better. So let's go through some of them. And we have wonderful materials put together. We've really toiled on them, actually. And there was a snafu with getting everything posted today. So some are posted today, but actually, look at them tomorrow too, because you'll see updated versions and more posted. I believe on the back of your name cards, there's like a link or something, right? Am I right? Yeah, cool. Okay. So more details in the program materials, highlights from me, and then you'll see simulations from some of our others. Okay. So, and some of the statutes I am going to talk about a little bit more in depth, and others I'm going to kind of go through quickly. I am going to talk a little more in depth about the Illinois Domestic Violence Act because I think it's pretty extraordinary, and I would love for every lawyer to really know it well. And it's apropos not only to family law and elder law, which I mentioned, but clearly criminal law too. It just comes up all the time, and it affects the criminal side as well. So a couple things to emphasize about this statute. The first is how broad the number of remedies there are on it. Normally when you think of an order of protection, you think, stop the abuse, stay away. But we have 15 other remedies here in Illinois. And those remedies, I'm not going to list every single one, but to just list some and give some categories. So you also have exclusive possession of the residence, which can be very protective when the petitioner, your client, shares a residence with an abusive partner. There's various child-related remedies. including restrictions on parenting rights. And I always like to say to the family law attorneys out there, because I don't think enough of them realize it, that the standard under the Illinois Domestic Violence Act to obtain restrictions on parenting and supervised parenting by the abusive partner, it's an easier standard to meet under the Illinois Domestic Violence Act than under the Illinois Marriage and Dissolution of Marriage Act. Under the Illinois Domestic Violence Act, basically it's a best interest of the child. You know, if it's not, and there's a presumption it's not in the best interest of the child that, you know, the primary care and possession of the child and the decision making be with the person who's been abusive. So that's really helpful. Now, of course, once the matter goes into, you know, outside of the order of protection, goes into a divorce or parentage case, that can turn around. But at least for this emergency period during this initial separation, you're getting an order of protection. That's an added protection too for the kids. Recognizing the connection between financial independence and safety, there are various financial remedies that you could get even at an order of protection at what's called the plenary stage, where the other side has been served. So you can get child support, you could get maintenance. If you've experienced losses due to the abuse, that's recovered too. And that includes attorney's fees. So if any of you are in family law again and you're handling an order of protection, assuming the other side has the resources and it's not going to deplete the marital estate, it can make sense to try to recover your expenses if you're not a clinic doing it for free to obtaining the order of protection under payment of losses. Then there's certain specialty remedies like relinquishment of a firearm, and there's a huge correlation, unfortunately, between abuse that ends up deadly and did the respondent have a gun. So being able to seize weapons is helpful. And then knowing the connection between pets, believe it or not, and domestic violence, that pets, beloved pets, are used as a weapon against the other party, so pets can be protected too. The IDVA is also, I would compliment it for also being very broad in terms of what is considered abuse, right? So it's physical abuse, but it also includes things like interference with liberty, intimidation of a dependent, which means engaging in domestic violence either in front of a child or actually causing the child to participate in the abuse. So that's called intimidation of a dependent. That's a basis to get an order of protection and to get a remedy against it. And I love that it's a recognition of the harm to children just from exposure to domestic violence, even if they're not the direct target of it. And in general, harassment. Harassment is defined as emotional distress, causing a reasonable person emotional distress. It causes that person that, and lots of things are picked up from that concept. And the statute even lists specific examples like repeatedly phone calling somebody at work and following them repeatedly and things like that. But it's even broader than those examples. The other thing that's broad is the definition of relationship. What's the relationship between the petitioner and respondent such that you can fit within the statute? What kind of abuse is covered? And by whom, I should say. So family or household members are covered, and it's expansive. And in addition to what you would think of for a family or household member, somebody you live with, somebody in your family, in addition, it's former and current intimate partners. It's even a dating or engagement relationship. And back to the elder abuse issue, it also includes adults with disabilities, the elderly, and a caregiver situation as well under the concept of neglect or exploitation. Now, our clinic doesn't happen to do elder abuse issues per se with a caregiver, but I do want to point that out, that the statute is broad and covers that as well. The other thing I want to call to your attention is that you can get an ex parte order of protection. And what that means for any lay people here is you can appear in court without first giving notice to the other party. get your order of protection, have that in place, have the person served, and then after that person is served and subject to the order of protection, then comes the contested hearing where, both sides can raise their arguments and their evidence. But what's the standard for getting the ex parte order? In a lot of states, they emphasize things like there had to be a recent serious physical abuse that's occurred. And in our statute, that is not required. I'm not saying what the practice might be always, but the statute doesn't require a recent serious physical abuse. Instead, ours recognizes what I was speaking about before, that the notice itself, I'm leaving you, I'm getting this order of protection, that's what's going to create the very abuse you're trying to avoid. And that's the language in the statute. It talks about that language, that the notice is likely to cause the very harm you're trying to prevent. So that's, I think, a wonderful standard. And oftentimes there has been a recent serious physical abuse when you go into court for an order of protection, so it's not an issue. But sometimes you have a situation where it might have been months because of that cycle of violence and the mollifying of the person. And, we have those cases, and we've got to deal with how are we explaining why the ex parte standard has been satisfied. So I wanted to call your attention to that. Illinois Marriage and Dissolution of Marriage Act, the key connection with domestic violence that I want to raise in this is that abuse of one of the parents, abuse of the child, I think even abuse of others, is a factor in determining what is in the best interest of the child, who should the child be spending time with, and who should be making the decisions, the major decisions relating to the child. So it's a factor. Many other states, I think I'm safe to say every state has that, but a bunch of states, at least a third to higher, have a rebuttable presumption when there's been abuse of one of the parents or towards the child. There's a rebuttable presumption that, primary care in custody goes with the non-abusive parent, and decision-making for them too. It is rebuttable, but we don't have that in Illinois, and we are working on some interesting reforms relating to custody, some custody evaluator reforms, but that goes beyond what I should be talking about today. I call to your attention, I could talk more about family law, but Christine Hunt put together a really wonderful document called 10 Things Every Family Lawyer Should Know About DV, and I call that to your attention. Take a look at that later, because I think she did just a wonderful job putting that together and giving some real practical, terse points to keep in mind. And plus, she's going to be doing a simulation where you'll get a sense of some other things. The potential duty to warn. I think I threw this in here under family law because I wanted to give you something to ponder that you hadn't thought about, but I think people who work in the DV field are already very aware of a potential duty to warn. Clearly in the criminal law area, they should be. So if your client has told you something that causes, this is under Rule 1.6c, if your client's told you something like they're gonna, kill, hurt, etc., somebody else, their spouse, under that rule, if the lawyer reasonably believes it's necessary to prevent the client from committing a crime, which is likely to result in death or substantial injury, they're supposed to warn. It's a very high standard, but still it's something that you should be aware of because you may be hearing things like that. I could kill her. Well, does that really mean that's what they're going to do? But you need to be thinking about that. So I call that to your attention. So now I want to move on to some criminal laws. One thing I want to say, and it kind of relates to orders of protection, is that it is actually crime. After the respondent's been served with an order of protection, if certain of the remedies have been violated, that's a crime. First offense, it's a Class A misdemeanor. A second offense, it's a Class 4 felony. So up to 1 year for a Class A misdemeanor imprisonment is possible. 1 to 3 years is possible for Class 4 felony. So there's teeth to this. It's not like a mutual restraining order, which this is the opposite of that, so to speak. I also wanted to mention, because I thought this was an interesting crime, because I know it happens, but I don't always think about it. Interfering with reporting domestic violence, taking away, preventing somebody from calling 911 or getting other kind of services is that crime. And I believe it's also a, I'll tell you in one moment, is also a Class A misdemeanor. Preventing them from seeking medical assistance. We had a client who was, badly injured and couldn't go to the hospital because of it, because she wasn't allowed to. And then the firearm issue that I spoke about earlier, this connection, because there is a connection between lethality and domestic violence when there's a gun. So under paragraph K of this statute, an abuser may lose their right to lawfully possess and carry a firearm if they were convicted within the past 5 years of a violation of an order of protection. They'll be denied a firearm owner ID card if they apply, or if they've already received the card, it should be revoked and it should be seized. So that's a remedy. And then paragraph 11 of that statute makes conviction of domestic battery and certain other crimes a basis for denial and revocation as well. There are a few other examples of criminal laws to mention to you. The first is there's an enhanced penalty when it's domestic battery versus an ordinary penalty. And I think that's there because it's a more dangerous situation typically when you're living with somebody and they've done this. And also, frankly, there have probably been 10 or more incidents before this that's led to somebody finally going forward and making a charge. That's not in the statute anywhere. That's just me thinking out loud. I want to clarify that. So it's a class 4 felony if there was a prior violation of order of protection or a domestic battery. And then there's interesting evidentiary rules. Normally there's issues about hearsay and prior bad acts, right? Illinois has some interesting statutes, they're noted below on that, where there's a different standard when it's a DV situation, and it kind of says if there's not a specific hearsay exception that would apply, here's the standard that you could try to apply for this, and also may permit prior acts of domestic violence to be raised in a criminal case relating to domestic violence. The need for this, sadly, there's two needs for this. One is oftentimes a DV survivor ends up having to recant. So the police come on the scene, they take a statement, etc., and in the moment, the survivor might explain what happened. Might not, but might. And then there's all this pressure and threats, and they'll have to pull back and not go forward. It kind of reminds me if you were attacked, by a gang, and then you're worried, how can you ever return home if you testify in the case? So there's a need. And then the other is even worse. Tragically, if somebody is actually killed, they've made some statements that are not considered, that are considered testamentary in nature, and now they're gone, they're dead. You'd want to, if you're the prosecutor, you want to be able to bring in all the evidence you can. So that's another reason for some of these different standards for domestic violence cases. I now want to switch over to child protection laws. Does anybody here work on child protection cases? Great. I'm missing a page. All right. Well, I'll just wing this one. So DV survivors are often in a catch-22 situation. On the one hand, in the context of a domestic relations case, if you try to seek an order of protection, or you try to seek supervised visitation, you're trying to protect your kids from further exposure to domestic violence or direct abuse, you're questioned, you're grilled. Why are you an alienating parent? Why did you do this now? And then you file for a divorce. Where's your evidence of this, right? So you get penalized often in domestic relations court, especially if the judges have not been trained to identify domestic violence. But if you don't seek an order of protection, you can get slammed by DCFS as being, a parent who's not adequately protecting your children from harm. So this was something that's been around for a while is a problem, and there's, anecdotes of children being removed from homes when maybe they shouldn't have been removed from homes, and you're actually penalizing somebody for being a victim of domestic violence when, they may be a very good parent and the child's very attached to them. One thing that's helpful is what's known as Rule 300. It kind of sets up a two-step analysis for this. First, you really have to show actual, imminent likelihood of danger and harm to the child. You can't just speculatively say it. So, there's got to be more of a showing of harm. And second, the parent who's being labeled neglectful, they can't remove the child and say that they've been neglectful if the parent's engaged in precautionary measures. But then the devil's in the details. What does it mean to have precautionary measures? And then there's the issue, I think orders of protection sometimes are a good thing, but sometimes it's really not safe to get one. And if we had some de facto rule, you have to get an order of protection or you're not engaging in precautionary measures, that's really problematic. And so I think that this rule tries to flesh out what are precautionary measures, what else is a precautionary measure, because I think that was the de facto practice to require an OP. And then there's the issue of just the financial independence, the ability to stand on their own feet. How can you ask somebody to take steps that either make them unsafe or, homeless, unless you're offering them resources? So I'm hoping that, a lot of these issues are not just what the laws say, but how they're implemented. So hopefully the DCFS caseworkers are trained, and we've had guest speakers from DCFS come and tell us about the training that their caseworkers have, and that's great, and I like to see that. The guest speakers really seem to show a real understanding and a balanced approach. So hopefully it seems like this is an area that's starting to move in a more positive direction. But I do think being in DCFS is a loss, lose more situation. Whatever you do, you're unfortunately gonna be blamed. You take a child out of a relationship, out of a family, and something happens in the foster care, you leave them in, something happens there. You tend to just hear the bad stories. Okay, now switching over, housing protections are really critical for domestic violence survivors' safety. The Safe Homes Act is a really great statute, and I'll explain why. Some survivors of domestic violence stay with an abusive intimate partner because they fear if they leave their home, they will still be on the hook for the remaining term of the lease and cannot afford to pay rent on a new place and owe money on the first place. Under the Safe Homes Act, survivors can terminate their lease early without being in breach of the lease when certain conditions are met. The Safe Home Act also provides a procedure to force a change of the locks. It's at the tenant's cost, so that's a real impediment. That could be too expensive for somebody to be able to do. If the survivor wants to stay at the premises, but would feel safer with that change in the locks because the former abusive intimate partner has a key to the place. So I like that there's these choices. You can terminate the lease early and leave if that's what makes you safe. You can, if you want to stay, you can, seek to have the change of locks. The key really is to follow strictly the requirements of the statute. So, and unfortunately, a lot of people aren't aware of the Safe Homes Act. I mean, the general population of the DV community. And so education is really key here. And we're going to have a simulation where some of these laws will be discussed. Kelly Walters is going to be leading that simulation. Then you've got, in addition to the Safe Homes Act, you've got an affirmative defense and eviction cases. So there's a Forcible Entry and Detainer Act, and it basically clarifies or states that a landlord cannot evict somebody solely on account of the their domestic violence status, and that that violence is taking place in the home when they're the victim of the home. Now, I said that very broadly. There's an exception that might swallow the rule. if there's actual imminent threat to other tenants, et cetera, that would be an exception. But the exception can't be speculative, and I would think that the landlord would have to, take some steps that the exception wouldn't apply. So you can't just say immediately, oh, there's this threat here. So if you have an order of protection, you give it to the landlord and you say, don't allow so-and-so to enter into here, and there's a door person, I think that covers it pretty well. There's also the Human Rights Act, and having an order of protection status is then you become a protected party under that statute. That picks up in two of our practice areas, our employment protections and housing protections. So that's also useful to know. Of course, there's a strong connection between domestic violence and the need for employment protections. I mentioned earlier that a major form of financial abuse is causing somebody to lose their job. And I think VESA, the Victims Economic Security and Safety Act, does a really wonderful job of trying to prevent that from happening. So everything from being able to take some time away from work to reasonable accommodations to where, to address the abuse, to no discrimination because of your status and no retaliation for exercising your rights. That's all there in the Victims Economic Security and Safety Act. In terms of accommodations, it could be something like if she works at night and she wants to work during the day, and there's an ability to shift, change the shift, that would be an example. And you'll actually hear of one in our simulation. So, and I already talked about the Illinois Human Rights Act. The Crime Victim Compensation Act, again, on this theme of financial, the importance of being on your own 2 feet. This is a marvelous statute. I think every state's got a Crime Victim Compensation Act, domestic violence, forms of domestic violence like battery, et cetera, would be covered under it. And you can get compensation up to $27,000 for your out-of-pockets or obligations you've incurred. And with our clinic, among other big expenses we've seen is, somebody's been battered, they may have a lot of hospital bills that they're struggling with, and those hospital bills can just sink you. And the idea that you could get recovery through an administrative process is really very helpful, and that's one of the things we do as a clinic, too. I should have thrown the Gender Violence Act up before crime victim compensation, so a little error there. Going back to employment, so I think employment lawyers, any employment besides Carlos Montoya, of course, any other employment lawyers here who do that kind of work? Okay, well, hopefully somebody viewing this video is. I think you'd be surprised to hear that under this statute, under the concept of assisting domestic violence or sexual assault at the workplace, that an employer who turns a blind eye to domestic violence going on in their workplace could have liability under this statute. So I kind of just throw it out that, as I say, there's so many laws that relate to domestic violence that different lawyers in different practice areas should be aware of. Now, we could have a 3-hour conference on immigration relief. And I am no expert on immigration relief, but I'll share with you some thoughts on that, and then we've posted some materials on that. We have some attorneys, this is their focus, but again, if I included all of the attorneys here, we would be here quite late into the night, so this year we did not include the immigration. But if you're a DV survivor and you're undocumented, you are in, I don't need to tell you, you're in a vulnerable position, a very vulnerable position. And if you're relying on an abusive intimate partner who has U.S. citizenship or a green card, then you're relying on that person to gain your status. And that's a huge power leverage. And so the Federal Violence Against Women's Act provides for self-petitions, again, when certain conditions are met. There's 7, I'll just quickly run through them just to mention them. There's 7 preconditions to getting a VAWA self-petition, to qualifying for one. And this is an area that our clinic covers as well. A marital relationship. The abusive spouse is a U.S. citizen or lawful permanent resident. The petitioner is currently residing in the U.S. There's some exceptions to that. At one time, they resided with the abuser. There was either battery or extreme cruelty, and an OP is one form of credible evidence of that. You can see how I keep referring back to OPs, by the way. The person applying is of good moral character, and that's a term of art used throughout immigration relief. And the marriage was in good faith. You didn't marry for the purpose of evading immigration laws. So that's a really powerful right, and a lot of people who've come into this country and they're new to this country, they don't know about some of these rights. And we try to do a lot of outreach, and if our immigration people were here, they'd say, yes, we do workshops at different community organizations. Some of our students come from, different communities. They're immigrants themselves, and so they'll talk in the native language that they have to community groups about these rights. So that's one. U visas are basically for the situation where, there's been a crime, and domestic battery is a qualifying crime, or it could be some other crime that qualifies. And you use that when you don't have the relationship, whether you're not married to the person, or the person who's abusing you is not a U.S. citizen, not a lawful permanent resident. You can't do the VAWA approach, so you do the U visa approach. And for this, you need to have suffered significant mental or physical abuse and be willing to help law enforcement investigating the criminal activities. And this is a way to become a lawful permanent resident, to start to be able to work under the law, things like that. And as this mentions, there's also T visas for trafficking. And then asylum is another possibility. We haven't gotten an asylum, our particular clinic hasn't gotten that yet, but that's when somebody is coming from another country, experienced domestic violence in that country, and the government there, local or federal, is not responding to it, and that's where you get the government persecution standard met through that, not protecting the DV survivor. They come here and then they're seeking asylum. So it's an uphill battle with that. It can be. The statute that it's under could be more clear, and instead you go under something called a member of a social group, I think it's called. I think usually things are better here in Chicago than in other parts of the country, but it's still, I think, a tough law to fit under. I think the VAWA and U visas are really more straightforward and an easier process, although there's a long waiting period for that. Another federal law that might surprise you because of the practice here is federal income tax. Any of you guys do tax work? Okay. Well, I like that our clinic covers that, because then I get people in the clinic who never would have thought they'd be in a domestic violence clinic, and they're all learning about DV, and I love that. There's a law that exists, the Innocent Spouse Relief, and equitable relief under it, where if your client receives a notice from the government, you owe $30,000, and they say the reason is you filed a joint tax return and you understated income, you overstated your deductions. Even if you've signed it, it's not a forgery, and even if you knew about it, if you can show evidence that you're a survivor of domestic violence and you feared retaliation if you didn't sign it, that could be the basis for this relief. We actually created some online interactive resources where anybody in the country can gain access to figuring out, do they qualify for this, and how to fill out the form. And that's should be on our website. I don't know if it is yet, but it should be, and I plan to be sending that out to DV service organizations nationwide. There's also some federal housing protections, and there's a very in-depth PowerPoint on that that's part of your materials, and this relates to public housing, federally funded housing under VAWA. So the Safe Homes Act that I talked about earlier, that really focused on non-public housing, but it could pick up Section 8? Mm-hmm. Yeah, okay. It's so nice to have a team. I would like to say that the federal law is really great on debt relief for survivors of DV, but it's not, I hate to say. there's not much there that is set particularly for domestic violence survivors. But having said that, there's a lot of protection under the federal law for anybody due to identity theft. And DV survivors definitely experience identity theft disproportionately. You know, an abusive spouse is going to take their credit card and is going to charge it up and put them under with something like that. That's very common. So the protections that exist for identity theft, you can freeze your account, you can get your report, you can contest it, you'd file a police report, the whole process, DV survivors can benefit from that. Having said that, and when we set this up as a practice area, I thought it'd be simple, because when I tried to get my credit report, it took me literally 4 minutes online to do it, but every single client who came into us could not get their credit report. Why? The identification language, asking about, you know, which of the following do you not have, and it lists like 3 or 4 mortgages. Well, you know, they don't know what's happened if there has already been identity theft. There's all kinds of transactions that are on there that they can't identify. They also have trouble giving their address. If you're currently in the shelter doesn't want you to give an address, and then if you give a P.O. box, it gets kicked out. But we have had some success in working with some of the credit reporting agencies to set up a protocol when we get this, this situation happens, what information can we give them as a clinic to address it? You know, there are ways to work around that. Okay, so now what I'd like to do is, we're at the stage, you know, I've kind of gone through the tier 1 and the tier 2. So tier 3 was kind of like everything else out there where there's ever a situation where you might be entering into an agreement. And if you're entering into an agreement, you're representing a client and they're entering into an agreement, a licensing agreement, trademark, a real estate deal, forming a limited liability company, whatever, how could DV come up? Well, if the counterparty is an abusive intimate partner, even if they have separate counsel, coercion is going to taint that. And we have a very interesting estate planning simulation that we're going to be doing with Gina Spada, who is our expert in estate planning. She's going to be doing that simulation. It was really fascinating. We actually ended up struggling with some issues mightily for a while. How to comply with ethical requirements and maintain safety for the client. So some interesting stuff there. Okay, so have I made my case? Do you think there's a duty to screen for domestic violence in order to competently represent clients in all 3 tiers? I argue yes. Why? 1, the prevalence of domestic violence. Whether you like it or not, whether you want to choose to see it or not, some of your clients are DV survivors. That's part of their foreground or background. 2, the realities of domestic violence, including they're not likely to self-identify to you, even in family law cases. 3, there are all these protective laws in diverse practice areas that relate to their status as being a DV survivor. And then 4, even in the most remote areas, there's still that coercion possibility. To kind of apply some of the rules and shed a little more light on this. So first, Rule 1.1, we're all familiar with that. All lawyers are familiar with that. You have a duty to provide competent representation. Legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Well, that sounds pretty vague. What does that mean? Legal knowledge and skill. So the comment to Rule 1.1 says, the most fundamental legal skill, and I kind of agree with that, although it's hard to say the one, but a fundamental legal skill is to determine what kind of legal problem a situation may involve. So, and I agree. Client comes to you, they start telling you facts in their concerns. They don't always say the right legal terminology. They don't always know. They come in saying, this is my problem, and this is the law that they're aware of, and then you see all these other things that they may not be aware of. So determining what kind of legal problems a situation may involve. In terms of thoroughness and preparation, inquiry into the factual and legal elements of the problem. Again, you're representing somebody who's, you don't know they're a survivor of domestic violence, and you're handling a family law case for them. you really need to know if they are, because it very much affects the matter that you're handling for them. But other practice areas can too. The employment, the housing protections, child protection, criminal law, all down the line. So screening is the first step to know if they are, if they don't self-identify. And then in terms of advice, I did a fair amount of research looking for any case law on this, or the equivalent of case law were these advisory opinions, ethics advisory opinions. And I found this one from Utah in 1998 that said that a lawyer has an obligation to advise a client of all lawful options to resolve a legal problem. And then if you look towards the end of it, this could lead to requiring an attorney to advise the client of the option of obtaining a protective order. So I believe that this supports the idea, if you're going to advise somebody of all lawful options, you have to really understand who they are, what all of their problems are, and what all the legal options are. And that means you'd need to screen for DV, you'd need to know the protective laws, you'd need to have best practices as well, which I think is the next point here. Okay, so the implications. You should understand and screen for DV. That's what I'm arguing. You should know the special DV laws that can arise in the matters that you take on. And you should know best practices when working with DV survivors. So, in terms of the screening, it would seem that if you're in type 1 practice area where it's the most likely that they are, in fact, a DV survivor and it's going to impact what you do, you should do what you need to do in terms of screening, a more detailed and thorough screening. If it's in practice area 2, I think it needs to be more tailored to the kinds of protections in your area and seeing if they're a DV survivor and how that might affect things. And then in the third area, you could do a brief one, kind of similar to what Kathy Doherty might be saying the doctors do, and then deal with the coercion issue and some other issues that Gina Spade is going to reference in her simulation. In terms of best practices when representing a client, this is a little bit of the tell instead of the show. There'll be some show in a minute. What are best practices? But in terms of the telling, actively listening in a supportive fashion is key. And I'm going to emphasize that every word there is important, but I'm going to focus on supportive. You want to be supportive. You have to be careful with the language you use. Especially, if your client says something and you can't understand why they did that, don't say, "Why did you do that?" Because this is a person who's been traumatized, and having somebody say, "Why did you do that?" is really harmful. So you want to be supportive. And I'm not going to say more about that. I think the simulations really do a better job than anything I could say. I think you want to collaborate with DV service organizations to perform risk assessment and safety planning. I think that's really important. And in fact, Gina's script for her simulation talks about how at times an attorney needs to go outside of the law and go to other experts. And this would be an example of that, I think. And there's what rule number was that? 2.1. That's what I thought. Yeah, another advisor here. Rule 2.1. And yet it's just a smart thing to do. Nobody would want to file an action for an order of protection and then their client is attacked after without having tried to assess the level of risk and do some safety planning. Working together to empower your client. I want to focus on the word empower. If somebody's been in a relationship where they've lost all of their agency, all of their ability to make decisions, you want to be especially sympathetic to that. And so when talking with them, everything should be open-handed, open-hearted, and discussing options and not saying, "Oh, you should do this, and then you should do that," but just describing the options and letting the client decide. It could be the case they're not ready to leave yet, and they just want information now. So you don't want to push them on that. And it could be it's not safe right now. They're not ready right now. But providing them the information, letting them decide, don't be disappointed if they make a decision you think is an unwise one. Give them the feeling that the door is always open. They can always come back to you or our clinic. When I talk about addressing the potential credibility problem What I'm referring to is that he said, she said issue. If aspects of domestic violence are counterintuitive and you don't have a lot of evidence of it and all you have is her story and his story, or his and his, or hers and hers, it's a problem. And there are techniques to try to build up the evidence that you can have by having the client journal, taking pictures, putting together every record you can. Maybe there were some hospital visits. I'm just giving a few examples, but it's something that you need to address. That's kind of number 5, collective evidence of DV when the relief requires that DV status. So that kind of builds into that. Being culturally aware. And there's a great article that I posted, and frankly, I have to give this attorney a lot of credit. Most of the clinic that I did create was based on reading her article. Her last name's Carrion, and it was an ISBA piece, and I just thought it was so wonderful. So the principles that she articulated, I've tried to fulfill in our clinic, and one of the many principles had to do with cultural awareness, which means recognizing that if somebody's from a certain group, they may have unique barriers and oppressions that they have to overcome, but don't presume, don't stereotype people. So just listen and take cues from what you're hearing, but be aware in the background of your mind that they may have some challenges that other people don't have. So, so somebody is differently abled. Obviously you're going to want to be thinking in the back of your mind, how could that be affecting things? Or if they're if they're an immigrant, and are they undocumented, et cetera, et cetera. I already talked about realizing some clients are not ready or willing to leave and not to be judgmental of that. And in fact, one thing you can do to address that, if they're saying to you, I still want to keep this marriage together, I think he can get better, what you can do with an order of protection, if she wants to get an order to stop the abuse, is you can combine that with counseling. And by counseling, I mean something like partner abuse intervention program or substance treatment program, whatever the causes, whatever are the causes of the domestic violence, you can kind of combine that if that's what the client wants. It doesn't necessarily have to be a stay away. But I would want to have risk assessment and safety planning as well. So I can't believe I'm on time. That was 1 hour. So our next 2 topics that we're covering tonight, this afternoon, how doctors screen for domestic violence as a way for, lessons for lawyers. And Kathy Doherty is going to be speaking on that. And after her, and I know there's some breaks in the middle, so I hope somebody will, Christine, you're always great at being organized, if you can keep track of some of those breaks, and we'll take them for bathroom, etc. As the students like to say, a mercy break. Let me out of here. So we'll take some breaks as noted in the program agenda, but I think we're going straight to how doctors screen. I think there's a small break after that.
Yeah.
And then we'll do the simulation. So thank you very much.
Well, that was relatively easy. So I'm Kathy Doherty, and I'm with the Chicago Metropolitan Battered Women's Network. And just a little bit about us. So we're 40 members strong, meaning that domestic violence and some of the sexual assault agencies in Cook County are members of ours. And so we as a collective work on policy and advocacy issues here across Cook County. We also have, we operate a statewide hotline. So that's been in operation for the last 20 years. We have also a centralized training institute where we do training across, some of it's actually statewide as well as countywide. And some of the pieces that bring me here today is that probably for the last 4 years we've had something called a medical response collaborative, where not only do we work with police as first responders, but we work with the medical community as first responders. So as we know, most of us go to the doctors when something is wrong. And so they have a prime opportunity then to take a look at the patients that they're seeing and get more information around a variety of particular issues. So in the medical community, one of the things that we talk with folks about is what are the benefits of screening your particular population, whether they come through your clinic or the emergency room or the OBGYN, wherever you see them. So clearly for doctors and nurses, folks coming in there, the benefits of being screened is that they're going to be able to provide better services for that particular patient. So they're going to better able to respond and identify to what's going on with that patient. There are certain accreditation standards that hospitals, healthcare providers need to meet, as well as just best practices. You know, when the Affordable Care Act came out, there was a recommendation from the U.S. Preventative Task Force that said that folks between the ages of 14 and 46 should be screened during, well-woman visit and not be billed for that, and also provide referrals and some brief counseling. Meeting the triple aim. So that's a medical term, right, in the healthcare community. So the triple aim is really about how do you increase your patient's satisfaction? How do you lower their healthcare costs? And by virtue of doing that, lower the healthcare costs in general, right? Because the healthcare community is not about spending a lot of money if they don't need to. So screening patients helps do that, because a lot of domestic violence survivors will come in with a variety of, some of them garden variety issues, right? Ongoing stomach ailments, ongoing headaches, aches and pains in different places. And so a doctor can do a lot of testing and virtually find nothing, right? So if they're not doing the right kind of screening, they're not going to get to what is the real issue there that they need to work with. When we work with the healthcare community, obviously, Deborah talked about 1 in 4, 1 in 3 women and 1 in 7 men are impacted by domestic violence. So whenever we work with the medical community, those statistics impact the employees of that particular institution. And so when we come in and talk about programming, those employees also benefit from that. At the end of the day, it's just the right thing to do, because they're going to get better services. The patient's going to get better services, the employee's going to get better services, and the healthcare community is going to be able to do a better job on what they need to do. So let's take a look at screening and inquiry and identification. So again, this is some of what you see here is related to some best practices screening questions that healthcare providers use. There are a number of different combinations of these things. However, they pretty much end up addressing some of these 3 basic questions. And the key to this is that just like any relationship, you don't walk in the room and fire away at these questions, right? In the medical community, and oftentimes if you're in the emergency room or you're in inpatient, they have what's called an electronic health record. And that requires that they ask a number of questions. I'm sure you've experienced, do you use drugs? Do you smoke? So these particular series of questions can be in the electronic health record. So as the medical provider is working with the patient, these will pop up. Clearly, the first part of this that you see up there is really important, because what folks want to, what will put them at ease is that the doctor letting them know that family violence is common in a lot of people's lives. And therefore, they ask all their patients these questions in order to better understand, what the patient might need. So they really set this up in a way that normalizes it, right? It doesn't make the person feel like I must be screaming that, I'm in a domestic violence situation, and therefore they're asking me these questions. So in the medical community, some of what folks do is ask questions that aren't specifically targeted to what they're actually wanting to know. So for example, we work with McNeil Hospital, who said that they were asking a universal screening question, and that was, are you safe in your home? Well, it's a universal screening question, all right, because you're not actually going to get an answer to intimate partner violence in that way. And sure enough, they weren't logging in that they were actually identifying anybody that was in a relationship such as that, because being safe at home can mean lots of things, right? Are you in a neighborhood where there's gun violence? Are you in an apartment building that, you have a poor landlord, so you've got, your sink isn't working, your stairs aren't working, the lights aren't working. So there's a lot of different things that could be happening, which doesn't get you the right response if you're looking for intimate partner violence. So these 3 questions are very targeted to what the person may be experiencing. And I would say that, going back to something that Deborah talked about, some of these questions don't err on the side of a complete picture, because financial abuse is very common. And so this doesn't actually get at whether someone's being financially abused at all, because that may be, but generally is not the only thing that they're experiencing in terms of abuse. Emotional abuse as well. I would argue that I would add a couple more questions related to this, even in the medical community, to find out what else is going on with them. So interestingly enough, I think Deborah was saying as well that folks aren't always comfortable asking some direct questions about something that you really need to know. We're working with Mount Sinai Hospital right now, and it's interesting that in their emergency room, they're actually asking these questions. But recently, the nurses on the floor in the inpatient felt uncomfortable, and so took these out of their electronic health record, which of course we're going to put right back in there, because it's important that these questions be asked. And it's interesting in the medical community, the kinds of questions that you're asked when you go into a doctor's appointment, right? So it's interesting to note that we often find that they're not comfortable with these questions. And where that really comes from is that they're not comfortable if someone says yes. They're not an expert, so the idea is, what do I do next? So we work with our doctors and nurses about setting up the question in an appropriate manner, but then also how we follow up with that. There have been studies that have been done that show that folks respond positively to these questions, meaning that when their healthcare provider asks them these questions, their impression is that their doctor, their nurse is concerned about them and concerned about their health. And so they appreciate the fact that these questions are asked, which of course, I share that with the doctors and nurses that I work with, but nevertheless, role playing through this is really important for them to get used to asking the question, because the most important piece of this is not so much the questions, although those are important. The other piece is that how are you developing a relationship with your patient or your client? So it's important that, as opposed to staring at the electronic health record where you're recording all the information, or saying, oh, I'm sorry, but, I just have to ask you these questions. Or asking the questions when their partner is in the room, because if your partner's in the room, you don't know whether that partner is an abusive partner. You're obviously not going to get any right answers to this if a person is in an intimate partner violent relationship. So starting out by really looking at your patient, talking to your patient, listening to your patient, a warm, empathic response, that's the kind of environment that you want to set up as you're going through any of the questions that you want to ask them, so that they understand that you truly are interested in their health and what's going on in their lives. The other piece that's important here is what in the medical profession is the warm referral. So it's not just that you're, again, in the electronic health record asking the questions, and if someone says yes, you hand them a business card with the hotline number on it. So you're responding to those folks, you don't deserve that, that is wrong, domestic violence is a crime. Would you like some further assistance on this? There's a hotline, whether it's a national hotline number, or in this case, we operate the statewide hotline, providing that information. Most hospitals have a communication and a connection with community agencies in their area. So they will make a direct referral to, whether it's Between Friends or whether it's Apnagar. There's a number of agencies in the community here. And will also allow a patient to call from their office so that if they want to get set up with something right then and there, they can do that. And the medical provider will provide a private space where they can do that. Some of the hospitals we work with actually have a domestic violence advocate on site where they can directly refer them. So Connections for Abused Women and Their Children have had a 20-year program at Stroger Hospital, so they can go directly to that particular advocate. Swedish Covenant, where we work, they have a response team. So there's the screening questions. If you've identified someone has said that they're in an infant partner violent relationship, then you move on to the next step, so that you're not the person that's providing the expertise, the treatment, any of those kinds of things, but you're concerned, you're providing a warm referral for those individuals to follow up on. So there's something, again, in the medical community that's called universal education. And what that means is that you can do all of these things, and a person might be in an intimate partner violent relationship, but they may not say that for a variety of different reasons. They're not ready to disclose, they're fearful, they're shameful, they're fearful that you're going to call the police. And then of course, that's going to cause more abuse. So what happens is that we encourage folks to set up a supportive environment. So not just how you're talking with patients, but what does the environment around you say? Do you have posters? Do you have brochures? Do you have palm cards that provide information about this particular issue? And Futures Without Violence has some really good palm cards where they talk about, they normalize the fact that there's lots of folks that experience family violence, and this is what it looks like, and here are some resources to call. So providing that information in the hospital environment, in the emergency room, around the different departments, it's there for anybody to pick up. Screening all patients. So I think Deborah showed some pictures of who we might think a domestic violence victim is or looks like. And that, of course, is a mistake. I do work with some medical professionals that have a stereotype in their mind, and so they only ask those particular persons, but they don't ask everybody. So with medical professionals, we should screen everybody. That's male, that's female, because everybody can be a victim of domestic violence. And I think 14 to 46 was chosen because those were childbearing ages. And our recommendation to our medical providers is that we would start younger, because we've seen kids in schools with in those kinds of relationships much younger than 14, and certainly much older than 46. And again, making sure that the information available is available to everybody. So not just female clients, but male patients and adolescent patients. I think quite simply, and Deborah has talked about this, that in finding out this information, you are able to plot out a better strategy for your client, right? Knowing this information then leads you to what are the laws and protections for your particular client in a particular situation. It also lets you know how you should be arranging the way that you're working with that client, knowing that their partner or ex-partner is abusive, because having conversations or understanding the power dynamic is really important there. It also allows you to increase. So legally, you're going to be working with your client in a very particular way, but it also allows you to benefit your client and their children in other ways, because you've now provided information to them that they can use when and if they're ready to use that, when they feel it's safest for them to use that. So those are some lessons, certainly that from the medical community, and I would certainly, I think we're talking about scripts later on, but certainly in some of the things that we've talked about here, I think it's beneficial, or it has been for the medical community, to really kind of take this information and then make it their own, so it feels comfortable and it rolls right off their tongue, and they're just flowing right through that. So don't expect, and the medical community doesn't, that this is going to mean a disclosure every single time. We get percentages from 1% to 2% to 10%, and on up, depending on how the environment is set up, right? These questions are asked.
Thank you.
Thank you.
So we're 10 minutes ahead of schedule. This is my 5th conference. That's never happened before. What I'd like to do, and then we're going to have a 10-minute break, bathroom break. Why don't we take some questions or feedback over the next 10 minutes? Then we'll take our 10-minute break, and then we'll start up with the next group. So some thoughts, questions so far? Yes, Neil.
I have a question for Kathleen. You mentioned, and Professor Stark mentioned before too, 1 in 7 men tend to experience domestic violence. Yet your organization, I believe, was Battered Women's Network. Does that tend to keep men away from seeking help from your group?
Well, it's interesting that you asked that, because before the Chicago Metropolitan Battered Women's Network, I worked at Friends of Battered Women and Their Children. And we changed our name to Between Friends, because Between Friends has the largest teen dating violence prevention program, and so we work with young men and women, and 10%, when I left there, 10% of the clients that we had, and that was in the counseling and the court advocacy program, were men. So it's interesting that you asked this question now, because we just got through with approving our strategic plan for the next 3 years, and one piece of that is to change our name. And I
What
think
would it change to? What are you thinking? What are you kicking around?
No, I don't know at this point, but there's probably two issues, right? Not just the women piece in it, but also, sometimes the term battered comes with a variety of different connotations to that. So in any case, we're taking a look at that, because we actually serve, a variety of different folks through our programs, and the hotline gets not only, male victims calling, but also perpetrators calling and wanting to find where services are. So
I think that's an excellent question. To elaborate on it, the federal law is Violence Against Women's Act. And there is this disproportionate that women are much more likely the victims and men the perpetrators, but lots of men are abused as well, and there should be adequate resources for it. A long time ago, when I was first teaching this course, I had a student run around. We created a little survey saying, we had the same scenario of abuse. It was emotional abuse, a little bit of physical abuse. And we asked people, do you consider this to be domestic violence? Is it the type of violence that should enable the survivor of it to get an order of protection? And we had 2 forms, one where the perpetrator was male and one where the perpetrator was female. And same thing with who the victim was. And lo and behold, same set of facts. The only difference was the gender. And more people who answered it thought that an order of protection was in order and that there was domestic violence when a woman was the victim and the man was the perpetrator, then role reversal. So I think that I always like to say there's different communities of people and with different vulnerabilities. And men have a vulnerability too, in that they're not recognized when it is the case, that they are a victim too. So it's a point well taken. But the statistics are kind of more likely, that it's women. So there's a reason, but still, we've got to balance the reality, the full reality.
Right. What's interesting to note is that if anybody takes federal money, which most of the organizations do, at least in this community, you are required to serve everybody. And that means everybody. That means male, female, transgendered. It means disabled, all of those folks. And so, that's been that way for years, regardless of whether they've called themselves Friends of Battered Women and Their Children or not. They're required to serve every population.
And then an issue is, how many shelters right now in Chicago take in men?
Well, that's another story. So as I just said, they're required to that. I would have to say that some folks don't do it as frequently as they should. And some of that is something that we're working on in terms of technical assistance. Because I think some of it relates to, how is the physical environment set up, and then what are the practices that might need to be changed differently or changed so that folks feel comfortable, all the folks feel comfortable in the environment. So that has still been a challenge that I find that some shelters are very hesitant about taking men.
Yeah, I mean, that's what I was imagining was maybe shelters that are geared towards men, just like there could be shelters geared towards women or men with older kids. There's all kinds of, with animals, there's different kinds of shelters, because I think it would be very hard on somebody if they've been through years of torture, by somebody, and sexual assault, etc., and then having men in the same environment where they're literally sleeping at night. I could see why that would be very traumatic. Mm-hmm. So, but there should be resources available, and I don't know if I would put the two under the same roof. Mm-hmm. I don't know about the law on that, if it's required, but it doesn't seem very sensible to me.
Mm-hmm. Well, I think they're required to serve the entire population. Right. So in my mind, we're at the other end of things now, where people are calling the hotline and they're looking for services. And so it doesn't feel good when there's a shelter bed available, but nevertheless they're not taking a particular individual because they're not comfortable. So now that I'm on this end of things, we're going to be changing some of that, providing some more technical assistance so that happens less frequently.
Maybe different floors. It's almost like college life. You can have different floors. It doesn't have to be co-ed by floor.
Yeah.
Any other questions, thoughts? Well, that's really great news.
Yeah,
Kathy's always doing great things. That is for sure.
Guys.
Thank you. So I think we should take our bathroom break, and we'll pick up again in 10 minutes.
Let's go.
For this first simulation, the prospective client comes in for a child support issue. Through screening, it's discovered that the client is a victim of domestic violence. The abuser is harassing the potential client at work, coming to her mother's home where she's residing with their children, and has caused damage to her property. It's discovered the prospective client would likely benefit from an order of protection and is protected by employment and housing laws. Furthermore, she may benefit from the Crime Victims Compensation Act. Hi, Miss Marshall. Thanks for coming in today.
Hi, Christine. Nice to meet you. Please call me Jane.
Thank you. Jane, before we get started, I'd like you to know that everything that you tell me will be kept confidential to the fullest extent of the law. Knowing that the consultation is confidential may make the client feel more comfortable and therefore be more forthcoming.
Thank you.
During our time today, I'd like to discuss your concerns, goals, and answer some of your questions. So what brings you into the John Marshall Law School Family Law and Domestic Violence Clinic today?
I need child support.
How many children do you have?
2, John Marshall and Sally Marshall.
And what are their ages?
Johnny's 4, Sally is 6.
And their father's Alex Johnson? Please note, a conflicts check was conducted prior to this initial meeting.
Yes, Alex Johnson.
Are you and Alex married?
No, we never were married. We did live together until last week. Alex has never paid child support and doesn't buy anything for the children. I was supporting the children entirely on my own, but I just don't have enough with everything that is going on at work and the cutback on hours.
What do you mean by everything that's going on at work? It's important to listen to the client and ask appropriate follow-up questions, which may lead to information that otherwise wouldn't have been learned.
Well, since I left, Alex has been showing up at my work and causing a scene, and because of it, my employer has cut my hours to part-time.
I'm really sorry to hear that you've been having a difficult time at work, and I can help you get child support for your children. I have a few questions for you about your relationship with Alex.
Okay.
Are there any special rules in your house?
No, I don't think so. We have rules in our house like most other people, but I don't think there's any special rules.
What kind of rules?
You know, like put down the toilet seat, no smoking in the house, that kind of stuff.
Okay, I have similar type rules in my house too. Everyone argues or fights with his or her partner or ex-partner. When you and Alex were living together, what happens when you fight? Do you ever change your behavior because you're afraid of the consequences of a fight?
We would fight somewhat regularly. Alex would get upset when I came home late from work, went out with my friends, didn't get all the dishes done, and things like that. I knew what to say and do to try and keep him calm, though.
You said you know what to say and do to try to keep him calm. Have there ever been interactions between you and Alex that have made you feel afraid?
I wouldn't say afraid.
Has Alex ever hurt or threatened you or your children?
That was part of the reason that I moved out. Last week I went out with a few friends to the bar, had a few drinks, and came home late. I'm a nurse, and I had a particularly bad day at work. One of my patients died, so I just wanted to, blow off some steam. When Alex saw how drunk I was, he punched me in the face and told me to grow up. He said, "You're a mom. You better start acting like it. You better never come home like this again. Grow up." I think Alex was just jealous and worried that I might have met another man at the bar. I guess I deserved it. Alex was still really angry in the morning, so I took the kids and figured we'd stay at my mom's house for a while until he cooled down.
I'm so sorry that happened to you. Are you still at your mom's house now?
Yeah, Alex seems even angrier now that we've left and keeps showing up at my work, Mercy Hospital. Just yesterday, he threatened me at work. He said, "You have until the end of the week to move back in with the kids, or you better watch your back."
Did he say what he meant by that, watch your back?
No.
What do you think he meant by that? What do you think will happen?
He has some not-so-great friends. He may send them out after me.
Have you thought about getting an order of protection?
No, I don't want an order of protection. I think that would just make things worse.
Well, if you change your mind or if you want any information about an order of protection, we can certainly talk about that, talk about your options in pursuing an order of protection. Can I at least provide you with a list of referrals for domestic violence service organizations? And some of these organizations have support groups where you can speak with other women who have been where you are in your shoes. It's important to let the client know that resources are available and she's not alone. A support group can provide a client with a sense of community and realize others are going through similar situations. If this were a real client and there weren't the time constraints that we have here in the simulation, this would be a good time to briefly explain some of the protections available in an order of protection and explain how an order of protection may be able to keep the client and her children safe. If the abuser is likely to adhere to the terms of the order of protection, then obtaining an order of protection is a good thing that may assist in keeping her safe. If violating an order of protection will have a negative impact on his life, there's a higher likelihood that he'll follow the order of protection. Indicators include whether he's employed and has a good job, whether he has a sense of community and a sense of belonging in that community, and also the stigma of being imprisoned, among other things that may be indicators. If he's likely to violate the order of protection and try to engage in worse violence, that it may not be safe for the client to obtain an order of protection unless there's other significant safety plans that are in place that can assist her with her safety.
I think that would be okay, thank you.
I can provide you with that list at the end of our meeting. So you had said that Alex has been showing up at your workplace, and because of that, your employer cut your hours?
Yes, I went from full-time to having my hours cut to 20 hours per week. My boss said I better figure out my personal life because if Alex shows up at work again, I'll lose my job.
It sounds like you may have a VESA claim. Why don't we set up a time for you to speak with our employment attorney? Are you available to meet with him tomorrow?
I'm afraid to take off another day of work tomorrow to meet with the attorney. Is there any way he can meet later today?
After our meeting's done, I can ask him about his availability for this afternoon, and maybe you can meet with him then.
Okay, thank you.
I know you came in here to talk about child support, so I want to make sure that we answer your questions about child support.
I just want to know what the process is and how much child support I'd likely get.
If you and Alex are living in separate households, you can file a petition for child support. The amount of child support will depend in part on how much each of you has with the minor children, as well as how much each of you earn.
So if I move back in with him, I can't get child support?
If you're living together, that's correct. You can't get child support from him. Are you considering moving back in?
He doesn't pay for anything for the children, or me. I just don't have enough to pay all the bills. My name's on the lease, and I can't afford to pay rent at 2 places. I just had to buy a new phone because during an argument a few weeks ago, he grabbed my phone out of my hand and threw it out of the car window and ran over it. It was completely destroyed.
Has Alex destroyed any of your other property, your clothing, objects in your home, or something else that you especially cared about?
About 6 months ago, he was furious at me for something and went into my closet and took a pair of scissors to several pieces of my clothing and completely destroyed about 5 tops and 2 pairs of pants. I couldn't believe he did that.
That's terrible. Has he ever destroyed anything else?
He's ruined or thrown away so many of my things, I can't even remember it all. I think the worst incident, though, was when he took my grandmother's pearls and ripped them off the strand to teach me a lesson. I was looking at a sale ad and mentioned how beautiful one of the necklaces were and hinted that maybe he would want to buy it for me. He got so angry, he stormed up to the bedroom, grabbed my grandmother's necklace and brought it down to the kitchen where he yanked off all the pearls and they scattered to the floor. As he did this, he said maybe next time you'll think and appreciate what you have before you start envying other expensive things. He knew what the necklace meant to me. My grandmother died a couple years ago, and that necklace was my only tangible reminder of her.
I'm so sorry to hear that, that you had to go through that. Thank you for sharing that with me. It's important to validate the client's feelings and realize that it can be difficult to share her story.
It was absolutely devastating. At least I was able to pick up some of the pearls, but he stomped on my hand and kicked some of the pearls down the air vent, so I couldn't even get the necklace restrung.
Did you report any of these events that you've described to the police?
No, I didn't.
You may also be eligible for crime victims' compensation, but you would need to make a police report or get an order of protection.
What's crime victims' compensation?
It's a fund that was established by the Illinois General Assembly to help reduce the financial burden imposed on victims of violent crime. Innocent victims and their families can receive up to $27,000 in financial assistance for expenses that were accrued as a result of the violent crime. If you want it, we could fill out the application together, but like I said, you would need to report the incidences to the police as soon as possible, or you would need to get an order of protection. You'll need to also continue to cooperate with the police after you report the incident. If you did file for an order of protection, you can also ask for payment of losses, including your broken phone, destroyed clothing, damaged pearl necklace, and other expenses that you incurred as a result of replacing the items that he damaged or threw out while abusing you, and that would be part of the order of protection.
I'm concerned about my safety. I don't want to report him if it's just going to make it more dangerous for me. But I'll think about it, and I'll think about getting an order of protection.
Okay, I certainly understand your concern, but I would highly suggest that you go to a domestic violence service organization who can do a risk assessment and complete a safety plan with you. You could also call the National Domestic Violence Hotline, and that number, if you want to take a note of it, is 1-800-799-SAFE, and that's 7233. If you do call the hotline, you'll reach an advocate who can speak with you about what's happening, how to stay safe, and what your available options are. Your conversations with an advocate would be confidential, just like our conversation is confidential. Before you came in for your appointment, you gave us 312-555-5555 as your phone number to contact you at. Is that a safe phone number? Does Alex have access to that phone? It's important to ask if methods of communication with a client are safe, because you could put the client in more danger if the abuser has access to her means of communication and is now aware that she's planning on permanently separating from him. Separation assault is a real danger and something that must be kept in mind.
It's a safe phone number. He doesn't have access to it, or the phone hurts.
Okay, good. And what about the email address you gave us? It's janemarshall@jmls.edu. Is that a safe email address? Does he have access to your email?
That's a safe email address. He doesn't even know about it.
Okay, great. We'll need to follow a schedule up meeting, but before we do that, do you feel safe at your mom's home? If there were no time constraints, the consultation likely would have discussed both the parties' financials and her desired parenting time schedule. It's important to also discuss with a domestic violence survivor client whether she's concerned that her ex might harm their children during his parenting time with them, why she has these concerns, and whether she would like to try to seek supervised or unsupervised parenting time.
Yeah, thanks. I do feel safe right now. I just need a little bit of time to think about how I'd like to proceed. I would, however, like to meet with the employment attorney right away if possible.
Okay. You also mentioned you may move back in with Alex because you can't afford rent at two places. It may also be helpful for you to speak with one of our housing attorneys. We can schedule a housing consultation for you as well if you'd like.
That would be really helpful. Thank you.
You're welcome. Our clinic also has other practice areas that may help you, including income tax, debt relief, immigration, estate and financial planning, and criminal defense. After you meet with our employment and housing attorneys, we can set up additional consultations for you in those other practice areas if you think that would be helpful. It's important for an attorney to be able to issue spot and be able to determine if a client has a potential legal claim in a practice area outside the attorney's area of expertise, but that is related to the legal matter they are coming to see you about, even if only tangentially related.
Thank you. I'll keep that in mind.
Just wait out in the lobby for a moment while I find our employment attorney's availability for the afternoon. I'll touch base with you by phone in a couple of days to schedule our follow-up meeting. Please try to stay safe.
Thank you.
So looking at this consultation, as Deborah said, we want to think about what type of legal problem is there. The client came in for a child support issue, and after completing the consultation, we realized that support isn't her most pressing issue. She's having all kinds of issues with her former abusive partner and is considering moving back in with him because of the financial aspects. As you also saw in this consultation, a victim of domestic violence may not always be ready to identify as a victim of domestic violence. You therefore want to be able to describe the legal options that are available, but also empower the client to make her own choice as to what's right for her and for her situation. If this were a real consultation, we would also go into some of the details of an order of protection, including the history of abuse, finding out when kind of the first situation happened, when the most recent situation happened, and find out all of the details surrounding those incidences. We would also want more information about who other possible protected parties would be, including minor children and details of the children being present for any of these incidences that she had described, or the children being forced to participate in the abuse. You'd also want to go through all of the available remedies that Deborah Stark had already indicated earlier today. You'd want to discuss her options for a stay-away order versus a no unlawful contact order. Some victims aren't ready to permanently separate from their partner, but do want to be safe from abuse and think a no unlawful contact order could protect them enough. The payment of losses remedy within the order of protection could also provide her with the child support that she's seeking. Also, depending on her financial circumstances, she may be able to get maintenance through that as well. She could also receive compensation for the damage to the clothes, the pearls, and the cell phone, as well as any other damaged property that could have come out in a full consultation. Relinquishment of firearms is also an important remedy. We didn't get any kind of indication that there was a gun in the household, but if there was, that would be something that we want to explore about having him have his firearms seized. Counseling is also another remedy that would be available, and you could talk to the client about different counseling options, including a partner abuse intervention program, substance abuse counseling, individual counseling, or any other kind of counseling that may be available. Exclusive possession of the home is also another one in this situation where it could be really helpful to the client. She moved out because she didn't feel safe in the home, but it's possible that through an order of protection, if she was granted exclusive possession, she could return home, remain safe, and her ex would be the one that would need to vacate the premises. We would also want to talk about the children and the parenting time, the decision making, historically what's happened, what she would like to happen in the future. And we would also want to talk about any kind of pets that were in the household, if those pets are in danger, if they're still at the household, or if she took them to her mother's home. It's been really rewarding working with the victims of domestic violence at the clinic. A lot of clients feel very empowered just learning about the remedies that are available to them and finding out that they're not alone, that there are resources out there for them, there are organizations that will help them, and that people like the attorneys and students at our clinic are willing to help them with their claim. I think that's everything that I have, unless you as the client wanted anything to add to the simulation.
No, I think everything in the simulation was very good, and gave me a lot of options, which was great. And they were options and not telling me what as the client to do. So I would say that it's good. It's great.
Then we'll move on to the second simulation.
Doesn't matter.
I don't care. Either way.
Centrally located.
Either way.
All right. Okay, now we're going to go into an employment consultation script. As was done earlier in the previous script, we will have some breakaways, but within the employment context, there is a law, as Professor Stark mentioned, called the Victims Economic Security and Safety Act, VESA, that is the primary law that protects domestic violence victims within an employment context. However, as Professor Stark mentioned, there are other laws as well that may be applicable. So our script will focus primarily on VESA, but there may be some interplay with some of the other laws. So we will go ahead and start the script. Hi, Ms. Marshall. Thanks for coming in today. It's a pleasure to meet you. My name is Carlos Montoya, and I'm a supervising attorney here with the John Marshall Law School Family Law and Domestic Violence Clinic. Please let me know what name you prefer for me to call you.
Hi, Carlos. Nice to meet you. Please call me Jane.
Great. Jane, before we get started, I'd like to let you know that everything we discuss here will be kept confidential to the fullest extent of the law.
Thank you.
During our time today, I'd like to discuss your concerns, goals, and answer some of your questions.
Okay.
Now, I understand you were recently the victim of a crime and are looking for guidance on employment protections. Is that correct? Okay.
Yes, sorry.
Okay. First off, who is your employer and where are they located?
I work at Mercy Hospital in Chicago.
And what is your job at Mercy?
I'm a nurse.
That's a very important job. So what I'm doing here is a couple of things. I'm establishing rapport with the client, stimulating, hopefully, further conversation and trust. But I'm also checking off a couple boxes, right? So when it comes to VESA, there are a couple requirements. It's a state law, so I had to verify that she in fact works for an Illinois employer or an employer that employs employees in Illinois. I also had to gauge the size of the employer. And finally, I wanted an understanding of what her job entails. Now, typically, this may entail follow-up questions. However, as someone who knows Mercy Hospital, I know it's a relatively large employer on the south side of Chicago in the South Loop. I know that they employ over 50 employees. And in checking off the boxes that I referenced earlier, we're trying to establish the size of employer, as I mentioned, because there are certain obligations that employers have under VESA depending on their size. For example, leave requirements. Under VESA, employers who have over 50 employees are required to give 12 weeks of leave per 12-month period. If they were under 50 employees but over 15 employees, they'd be required to give 8 weeks of leave. Effective January 1, 2017, VESA has been amended to be applicable to all employers. Anyone who employs at least one employee now has to give their employees at least 4 weeks of leave under VESA in a 12-month period. So again, checking off boxes, trying to gauge how big the employer is, also trying to gauge what her job entails. In this case, there wasn't much follow-up, but in other cases, there may be follow-up with respect to the essential functions of a job. That's because VESA applies to employees. There is a legal distinction between employees and independent contractors. Independent contractors are often people who come and do work for a defined short period of time and then move on, typically on a freelance basis, to other employers. They're paid differently. They don't receive benefits. The employer does not withhold taxes. These are all things that are applicable when we're, again, trying to assess the applicability of VESA. What are some of the issues that you're facing at work?
Well, since I left my ex, Alex, because of the abuse incident, he's been showing up at work and causing a scene, and because of it, my employer has cut my hours to part-time.
I'm really sorry to hear that you've been having difficulties at work.
Yes, I went from full-time to having my hours cut to 20 hours per week. My boss said I better figure out my personal life because if Alex shows up at work again, I'm going to lose my job.
It sounds like you may have a valid claim under the Illinois Victims Economic Security and Safety Act, otherwise known as VESA, which is a law that offers specific employment protections for victims of domestic violence and sexual assault. Let me ask you a few additional questions. First, is your employer aware that you were a victim of domestic violence?
Yes, I told my manager about it the day after the incident occurred because I had to make arrangements to move in with my mom and was late for work. Because I was a few hours late, he counted it as a full day unexcused absence, which could subject me to termination if I have another one.
Okay, VESA provides 3 very important employment protections to victims. First off, it requires your employer to allow unpaid leave for victims to deal with issues related to the domestic violence incident. Therefore, any time that you need to take off to attend to safety needs for you or your children related to the incident would be covered under the law, and your employer is required to allow you this leave. The amount of leave that you may utilize depends on the size of your employer. For an employer like Mercy, that employs over 50 people, you would be entitled to take up to 12 work weeks of time off during a 12-month period. You are required to give your employer at least 48 hours of advance notice, except in cases where it's not practical to provide such notice. Now, I just want to break away for a second. I brought up notice. Under VESA, there is a requirement that at least 48 hours of notice be given before requesting leave. However, there is a carve-out that that notice is not required if it's not practical. What does that mean? Well, it could mean many things. It could mean that you are in the hospital and you cannot provide such notice to your employer. Oftentimes, things are moving very fast. You may have been the victim the morning of a day that you're scheduled to go to work. Therefore, again, the 48 hours notice would not be practical. Certainly, I think that when it comes to notice, there's always a question of whether it's required that it be written. The answer to that is no, but. So it's no, it can be verbal notice, but the employer is within their right to ask for certain certification documents. Certification documents are outlined by the law. Essentially, your employer, before complying with the law and allowing you leave, is required to, is obligated, let me take that back. You are required to provide a sworn statement, and the sworn statement can be as simple as a written letter saying, I hereby swear that I was a victim of a crime on this date. It should be signed, ideally notarized. In addition to that sworn statement, your employer may also require supporting documents. Supporting documents are also outlined by the law. It can include anything from a police record, a police report, a doctor's note, a court record, even a letter from a victim services organization. Those are all appropriate supporting documentation to provide in addition to your sworn statement. Again, these are obligations under the law that if the employer insists on having, you are required to turn over, or provide, I should say. Okay. Was there a reason you could not provide 48 hours notice? It sure sounds like it.
Yes, the incident occurred very late the previous day, and when I saw that he was still really angry in the morning, I knew I had to make immediate arrangements for the sake of the children. There was no time to delay, and that is why I made the decision, even though it made me show up late to work.
Okay, we can draft correspondence to send to your employer notifying them of your leave rights under VESA for future reference, and also asking them to excuse your previous absence.
That would be great.
Okay, go here. Now, 2 things. One is, again, we kind of discussed earlier the differences of the 48 hours notice versus what's practical. In this case, she's provided a scenario, or she's provided facts that shows that it wasn't practical to give that 48 hours notice. Also, another note is that typically large employers are generally aware of VESA, but oftentimes many smaller employers are not. But even among larger employers, it may take several people before you get to someone who knows the law or is willing to research the law. Certainly, I work for a big company, and I know that, generally speaking, if VESA is brought up, there might be half of HR that doesn't know. There might be some people in legal who don't know of VESA, period. Certainly, they wouldn't know of what the specific requirements of VESA entail. So, that being said, keep that in mind. We'll continue with the script now. Okay, the second protection that VESA provides is freedom from retaliation by employers against domestic violence victims. Therefore, if they cut your hours solely because your abuser kept showing up at your job, or if they threaten termination if he shows up again, this would be a retaliatory act prohibited by VESA.
Wow, I'm relieved to hear I have so many protections.
Two things on this one. Again, sorry, keep kind of without my proper sign. So one is that this is a script, but certainly that response is one that I hear frequently. Oftentimes, as I had mentioned earlier, people just generally aren't aware of VESA. They aren't aware of employment protections within a domestic violence context. So oftentimes it can be empowering for victims to hear this for the first time, that they have protections at work. Also, I would point out that we discuss retaliation. So VESA, we're going to hit three themes. We've hit one already, which is the leave. The second one is freedom from retaliation. And now, retaliation can take two distinct methods. One is employer retaliation against an employee because they utilize rights under VESA. So the employer finds out you took leave, or you take leave under VESA, and they retaliate against you because of that. The other retaliation, or form of retaliation by an employer, is retaliation against an employee solely because of their victim status. So you may not have utilized any rights under VESA, or any leave, for example, under VESA, but if they know that you are a victim of a crime and they take action against you, adverse action, specifically or solely because of that, then that would also be retaliation prohibited under VESA. Furthermore, the third protection allowed by VESA is that your employer must provide reasonable accommodations requested to help ensure your safety at work. If your abuser keeps showing up at your work, you could potentially request that he be barred by security, or you could request a shift or location change so that he would not know when or where you worked. I believe those would all be reasonable accommodations given the situation. Now, I want to break away here because we've hit the third major component of VESA, right, which is, so we talked about leave, we discussed retaliation briefly. The third part, which again is not widely known, is the reasonable accommodations aspect. These are basically, the law permits an employee to ask for reasonable accommodations from their employer to keep them safe at work. Now, if you think about it, oftentimes victims are most vulnerable at work. Think about if they're separating from an abuser. That's one place that abuser knows when and where to find you. They presumably know where you work and what your shift is. So reasonable accommodations, pointing at some examples, would be a change in the work shift. It could be working at a different location. It could be something as simple as changing your phone number so that your harasser can't, or your abuser doesn't know how to contact you or call you or harass you. So those are all examples of reasonable accommodations. So what is a reasonable accommodation? I guess if we have to flesh it out, it's important to understand what that is. Now, the way I would define it is that a reasonable accommodation is anything that doesn't impose an undue burden on an employer. Well, the second question is, what does undue burden mean? It's very fact specific oftentimes, but generally speaking, it takes into account factors such as what is the cost to the employer? Obviously, a big employer versus a mom and pop store, there's going to be different thresholds with respect to that analysis. What is the cost to the employer? What is the impact on the primary operations of the employer? These are all factors that would be considered and weighed against what would be the safety benefit to the victim employee. These can be very fact specific, and they often play out that way in court. But I just want you to be cognizant of the reasonable accommodation provisions under the law and kind of flesh out what that means. Okay. Have you filed an order of protection?
No, I previously thought it would make matters worse, but after my consultation this morning, I think I'm going to meet with a DV service organization, complete safety planning, and then get an order of protection.
Yes, I think that would be a good idea. Besides the increased protection it would offer you, the Illinois Human Rights Act protects you from any employer discrimination based on your order protection status.
I'm sorry, I think I had to break away there. I apologize.
That's right.
That's very good to know. Thank you.
I'll break away now. Okay. So I just kind of threw in another law there. I didn't throw it in. It was applicable to what the victim was going through, and it was within certainly the context of the consultation. This is in talking to this victim, it certainly appears that there's an issue in which an abuser is coming and harassing her at work. Certainly an order protection is something that would offer protections, as the name implicates, in that circumstance. There would be repercussions if a victim or an abuser violated an order protection. But apart from that, there are also employment protections under the Illinois Human Rights Act. The Illinois Human Rights Act is an act that prohibits discriminatory actions based on certain protected classes. The Illinois Human Rights Act specifically defines having an order protection as being in a protected status. So it would be a protected status just like discrimination because of your race, gender, disability. Discrimination against someone because of their order of protection status is a discriminatory act under the Illinois Human Rights Act. And we'll continue. With respect to your reduced hours, I'll draft a letter to your employer notifying them of the non-retaliation provisions outlined by VESA and also request the immediate reinstatement of your prior work hours.
What if they refuse? They probably will.
Well, then we could file a VESA complaint with the Illinois Department of Labor. Their actions would be subsequently investigated, and if they were found to have committed a VESA violation, they would be required to pay damages, including any lost wages or benefits that you suffered from the date of their action. They could also face other liability and be ordered to reinstate your prior work hours.
That is so good to hear. Thank you so much for discussing my legal options with me. I feel a lot more confident knowing what employment protections are available to me.
No problem at all. I look forward to helping you in any way I can. So that's the end. I just want to leave off with one more breakaway. So the ultimate remedy against an employer who has violated VESA is to file a complaint with the Illinois Department of Labor. Procedurally, once a complaint is filed, the Illinois Department of Labor will investigate it. They will, in fact, assign an investigator to it. The investigator may interview individuals, certainly from your employer. They will probably interview you, first of all. There may be a conference called the fact-finding conference in which there is an opportunity for the investigator to question both employer representatives and you as the employee. And ultimately, there will be either a finding of a probable cause or no cause, a reasonable cause, I should say, or no cause. Ultimately, if that is the recommendation, it will go to a administrative law judge within the Illinois Department of Labor. Now, the administrative law judge will conduct a hearing, which will be more like an adversarial type of hearing. Again, in this hearing, there will be rules. There will be an opportunity to present witnesses. There will be opening arguments, closing arguments, and then ultimately, an administrative law judge will make a finding with respect to whether a VESA violation has occurred, and the Illinois Department of Labor ultimately must sign off on what that judgment is. And so again, just want to leave you that the ultimate remedy is a VESA complaint with the Illinois Department of Labor. So that's kind of the hammer to enforce your rights under VESA. And that's all I have, and we'll open it up for questions.
I wanted to ask, it sounds like a tough spot for employers.
Actually, since we're recording those simulations, can we wait till the end?
Sure.
Sorry, that's all I have for the purposes of the script. Do you have anything, Ms. Walters?
No, that was very good and told me a lot more about VESA than I knew, actually.
Good. Can we open up for questions? Sorry.
Yes, so the next simulation is going to be, is going to be in the housing section. My name is Kelly Walters. I'm the supervising attorney for the housing section of the Domestic Violence Legal Clinic at John Marshall. And Mr. Montoya is going to play the client in this particular simulation. So, in mine, I think I'm actually, rather than doing breaks from the simulation, I'm going to just sort of save everything till afterwards, just so you know. Good afternoon, Ms. Smith. I'm glad you were able to come in today. My name is Kelly Walters, and I am the supervising attorney for the Housing Protections Practice Area of the Family Law and DV Clinic. Can I call you Jane, or would you prefer Ms. Smith?
Jane is fine. Thank you.
Okay, before we go any further, I'd like you to know that everything we discuss here is confidential and protected under attorney-client privilege to the fullest extent of the law. In addition, I will need you to review this limited scope engagement letter. It outlines that at this point, the only legal services we are offering in this consultation, it outlines that at this point, the only legal services we are offering is this consultation. Please take a look at it, and if you don't have any questions, please go ahead and sign it.
I can sign. I received a copy of it after my other consultation this morning.
Okay, great. Well, why don't we talk a little bit about your housing situation?
Well, my ex is harassing me. I see him on the way to work, and he stands outside the window of my mother's home, where I am currently living, just staring up. The first day he tried to give me flowers, but then, after I asked him to stop following me and contacting me, that our relationship was over, it escalated to him yelling at me, calling me names, and threatening me through the window. When he does this, he also texts me to let me know that he is watching me. I want to have as little contact with him as possible. My mom has asked me to move because there is just not enough space for me and my kids where she lives. But the apartment where I was living before I moved with my mom is where my ex lives. So I would like to move out of this apartment and find a new place to live instead. But I fear I will lose my security deposit if I do that and will be sued by my landlord for the remaining 8 months of rent.
I understand. Well, the good news is that there is a statute here in Illinois called the Safe Homes Act that we may be able to use to help you terminate your lease early and not lose your security deposit or be subject to paying further rent if you terminate the lease. But first, I need to get a little bit more information from you. Is your ex-boyfriend's name Alex Johnson?
Yes.
Okay. How long has he been following you and contacting you in ways that are upsetting you?
Ever since we split up.
When was the last time he was standing outside your window at your mom's house?
Last night.
Okay. Do you have an order of protection?
No, I'm afraid that will just make him more angry. But Christine provided me with the contact information for a domestic violence service organization who I will contact today for a risk assessment and to create a safety plan so I can decide if it is safe for me to file an order of protection.
Okay. I think that's a valid concern about making him more angry. If you are interested in getting an order of protection after meeting with the DV service organization, we can set up an appointment for you to speak with Christine again about how to obtain that and the remedies they provide. Otherwise, I can provide you with a couple of referrals for you to review on your own.
Okay, I'll let you know if I'd like an appointment for that after I meet with the domestic violence service organization.
Okay. Well, if you'd like our office to set up an appointment, just let us know, okay? In addition, it could be useful for you to know that if you do have an order of protection that a landlord is aware of, the landlord is not permitted to refuse to lease space to you based upon the fact that you have this order of protection.
What does that mean?
Let me be more clear here. Under the Illinois Human Rights Act, possession of an order of protection makes a petitioner a protected party. A potential landlord cannot refuse to rent to you specifically for that reason. Unfortunately, that does not prevent him or her from refusing to rent to you for other reasons, such as your credit score being too low, or unemployment, or insufficient income to pay the rent. I just wanted you to know your housing rights if you do decide to get an order of protection and decide to move to a new leased space.
Thanks. I was wondering how having an order of protection would affect my apartment search. Christine mentioned to me that if I do get an order of protection, I should carry a copy of it with me at all times and share it with my employer and landlord so they are aware not to let my ex into the office or apartment building.
Yes, that is good advice. I now want to return to your goal of moving from your current apartment 8 months early without losing your security deposit. I have some further questions so we can determine what steps you can take so as you will not be in breach of your lease if you decide to leave the apartment early and stop paying rent. Are you and Alex married?
No.
I see from the intake form that you have 2 children. Is Alex the father of your son and daughter?
Yes.
Did you and Alex live together?
Yes.
Was that in the apartment in which you currently live?
That is where I was living until last week when I moved out with our children to my mother's home. That's the lease I'm hoping to terminate.
Okay. Is this apartment part of public housing or a publicly funded housing like Section 8?
No, it's not public housing, and I am not aware of any public funding for my apartment.
Okay. I only ask this because different laws apply depending upon that. Is his name on the lease, or are any other people on the lease or living with you?
His name is also on the lease, but no one else's names are. He and I live there with our 2 children. He is still living there with all my stuff, and Johnny and Sally's stuff is still there. I am thinking of moving back just because I can't continue to stay at my mom's, and I can't afford to pay rent at 2 places. But if I could terminate the lease early without losing my security deposit and without having to pay double rent, then I would like to leave that apartment and move to a new apartment that Alex does not know the location of.
I'm really sorry to hear that Alex has been following you and showing up at your mom's house after you separated. Does this make you feel afraid?
Yes.
Do you also feel afraid to move back to your apartment?
Yes, I really don't want to go back, but I feel like I don't have any other choice.
Okay. Please tell me more about your fears of moving back to your apartment. What do you think will happen if you move back?
I am sure that Alex will start yelling at me and may strike me too.
What makes you think that he will yell at you and may strike you if you move back?
Because he has done this to me in the past.
I know it may be very difficult for you, but can you tell me more about this? Knowing more about what makes you afraid to continue living at the apartment will help us exercise your rights under the Safe Homes Act.
Okay, the best way I can explain my life with Alex is there is a bit of a roller coaster. At times he is super nice, but then if I go out without him at night, even just with my family or friends, he often yells at me and accuses me of cheating. Sometimes, especially if he has been drinking heavily, this leads him to also slapping and pushing me. One time after I came home late, he sat on top of me, punched me in the stomach, and spit on me, and called me a whore.
Oh, thank you for sharing this with me. Really brave to be telling your story and taking the steps that you need to get help.
Also, I'm concerned that if I return to the apartment when Alex starts yelling again and striking me, we will be evicted, and the eviction will hurt my chances of finding future landlords who would rent to me.
Well, as a victim of domestic violence, you do have some protections if your landlord attempts to evict you.
Like what?
Well, an amendment to the Illinois Forcible Entry and Detainer Act has made being the victim of a domestic violence an affirmative defense to an eviction action. To be clear, this means your situation could potentially defeat an eviction, a cause of action your landlord might bring if the eviction is solely due to the domestic violence, like Alex yelling and engaging in violent conduct.
Really?
However, you would need to provide some type of documentation attesting to the violence. For example, that could be a police report, court records, medical records, obtaining an order of protection as we talked about, or even a written document reflecting that you received services from a victim service organization.
What about Alex?
Well, pursuant to the statute, your landlord could still seek possession against Alex as the perpetrator of the violence.
That is good to know, but if I can leave the apartment and not lose my security deposit and not owe further rent there, I would prefer that.
Okay. Have you spoken with your landlord about terminating the lease?
I asked the property manager about that possibility.
And what was their reaction?
She said I could lose my security deposit if I stopped paying rent. She also said that I could be liable for the rent on the place until they found a new tenant to move in.
So the good news is, in light of what you've told me, you appear to qualify for protection under the Safe Homes Act against losing your security deposit or owing additional rent for the period after the termination.
That is such a relief.
The Safe Homes Act, to be clear, is an Illinois statute that allows victims of domestic violence and victims of sexual assault the opportunity to terminate their lease early, provided they meet all the statutory requirements. Specifically, to exercise your rights to terminate the lease without losing your security deposit or owing additional rent, you must first have a credible and imminent threat of harm to you at your leased apartment at the time you vacate the apartment. And you must send a written notice to your landlord within 3 days of vacating the apartment. Then the reason must be for this credible and imminent threat. You do, however, need to have paid for rent due for the period of time prior to your notice and vacating the apartment. Let us know after you receive a risk assessment and safety planning if you would like us to prepare that paperwork with it for you.
That sounds great.
I should also note that the Safe Homes Act also provides the option to have your landlord change your locks or give you the right to change your locks yourself as a means to become more safe. If you reasonably believe that you are under a credible imminent threat of domestic violence or sexual violence at the premises and you provide written notice to the landlord that you are exercising your rights to this under the Safe Homes Act and evidence in support of your claim, such as the medical records, the police report, a statement from a victim service provider, as we discussed before. However, when the abuser is a co-signer on the lease, you would instead need a plenary order of protection that grants you exclusive possession of the leased premises in order to be able to change the locks and exclude the abuser from the leased premises under this act. You also need to share a copy of that order of protection with your landlord.
Okay, so if I'm understanding my options, I can decide to terminate the lease and move to avoid Alex, or try to get an order of protection and exclusive possession to force Alex out of the apartment and to change the locks.
Yes, that's a great summary of your options. Also, if you're interested in the remedy of changing your locks under the Safe Homes Act, the statute requires that you pay for the cost of changing the locks.
That might be expensive. Also, how do I know what is a credible and imminent threat?
That's a good point and a very good question. The fee the landlord charges to change the lock cannot exceed the reasonable price customarily charged to change a lock under the statute. We can check that out, but I think that they currently run around about $150. In terms of what is a credible and imminent threat of domestic or sexual violence at the premises, a couple of examples in the past have been when an abuser comes to his victim's work and they fear that he will next come to their home, when an abuser waits outside of his victim's residence, or if an abusive ex-partner knows where the victim lives.
Okay, that sounds like it could apply to me.
If you're interested in the change of locks option, I would recommend sending the notice and the required order of protection, since your boyfriend is also a tenant under the lease, by certified mail. This will provide you with confirmation that it was received by your landlord. Your notice should be dated and signed, and if you seek instead to terminate the lease, you'd want to indicate precisely when you want to terminate the lease.
Okay.
We will be sending you a document called the Next Steps Forms. It outlines the concerns and goals you have expressed today and the remedies and options we have discussed. Is it safe to send this document and any other documents to your mother's house?
With Alex stopping by daily, it may not be safe.
Okay. How would you prefer for us to contact you and send you documents?
Well, I've set up an email that Alex doesn't know about. He has the password to my previous email account. I think he has checked it because there are some emails that appear to have been read and it wasn't by me.
Oh, okay. Well, I'd like to thank you for coming in to talk to us today. I hope we've been able to shed a little light on your options under the circumstances. Did you have any other questions for me today?
No, I think that's everything.
Well, it's been a pleasure meeting you. I will send you the next steps form pursuant to the email that you told me about. Let me walk you out. This building can be confusing.
Thank you.
Oh, hi, thank you. So with respect to that particular simulation, there were a couple of things I just wanted to point out. A little bit, some of them are going to be a little bit redundant because I think both Carlos and Christine mentioned them earlier, but obviously it's important to indicate early on that your conversation with the client is confidential under attorney-client privilege. This could mean a lot when you're talking to somebody who's been the victim of domestic violence or sexual assault, because they might for the first time in a long time be in a safe place, and their communications with somebody else aren't going to put them in a greater danger. Also, as mentioned previously, we double-checked to see if the ex-boyfriend's name was Alex Johnson, and we did do a conflicts check prior to that. Okay, you'll notice that, well, we all asked whether I've already forgotten her name, I'm sorry, whether Ms. Smith had an order of protection. And the reason we did that is because whether somebody does or does not have an order of protection can vary how the Illinois laws apply to them, especially the housing laws. And that's particularly when an abuser is on a lease, as is the case in this particular simulation. You'll also notice that throughout the simulation, I said things such as, I think this is a valid concern, I can understand why you'd be fearful of this, and I believe Christine and Carlos did too. And it's just important to validate someone's fears and concerns, particularly in situations such as this. You'll notice I also asked if the apartment is part of public housing or publicly funded housing, like Section 8. And that's also important because there's different laws that apply to private housing versus public or Section 8 housing. Again, that's another validate thing. Also, you'll notice that when Jane went and talked to her landlord said, you know, that she could lose her security deposit and she could be liable for the rent of the place until they found a new tenant. And that's an example of perhaps the landlord might not actually know about these remedies. So that's something to always consider. With respect to the housing, there's just a couple of things I wanted to also contribute, and I won't take up too much more time. But some of the handouts that you received today deal with a lot of the federal law, specifically with the Violence Against Women Act and the HUD regulations with respect to that. And that's important because the Violence Against Women Act does deal with public housing and Section 8 housing, but it does not deal with the private housing. Unlike the Illinois laws that we talked about in the simulation, specifically and probably most elaborately, the Safe Homes Act. That's a pretty big deal for Illinois because only a few other states actually have legislation that's comparable to that. It allows, as you heard, a victim of domestic violence or sexual assault to terminate their lease early without losing their security deposit or having to pay rent for future months. It does also give them the opportunity to seek or change the locks. They can do this through the landlord or they can do this through a self-help remedy. The tenant is still responsible for the cost of the lock change. And it is very important to point out that with the Safe Homes Act, in order to terminate one's lease or in order to change one's locks, there has to be written notice to the landlord, unlike with the VESA claim. That's correct, Okay. Also, as you probably heard, it's important for the Safe Homes Act that if Jane is going to be successful in changing her locks, she's going to have to provide a plenary order of protection to her landlord because Alex is on the lease. If he were not on the lease, then that plenary order of protection obviously would not be a necessity. Also discussed in the simulation, I'm sorry, before I move on, the Safe Homes Act, it's important to point out that the Safe Homes Act also does apply to the victims of sexual assault. So if someone is just experiences one evening of being sexually assaulted in their home, this particular act would also apply to them. And so do all of the requirements for the written notice within 3 days of terminating the lease or changing the locks. Also discussed in the simulation was the Illinois Human Rights Act. And as you also heard, not to be redundant, but the possession of that order of protection does make a party a protected party and cannot be refused tenancy because of that order of protection. However, as also said, the landlord does have the right to refuse tenancy based upon credit issues, income issues, or whatnot, or other reasons, that is. And lastly, the other Illinois statute that's discussed in the simulation is the amendment to the Illinois Forcible Entry and Detainer Act, which provides an affirmative defense to eviction, meaning that if a victim of domestic violence is evicted from her home, she does have the opportunity to say that this was due to an incident of domestic violence and should not be evicted, and she has the ability to sort of overcome that particular cause of action. In order to do that, she is going to have to provide to the court or the landlord some type of documentation, as we talked about, which could be medical records, court records, or a written statement from a victim services organization. And the landlord does have the right to pursue the eviction proceeding against the abuser at that time. And I believe that's all I have.